So, imagine you're a Luxembourg wealth manager, right?
Okay, I'm with you.
You sell a completely legal, highly regulated, totally standard financial product. But simply because the person buying it happens to answer their phone while sitting in their living room in Brussels, your entirely legal product just triggered a massive cross-border compliance violation.
Oh, yeah. Which sounds crazy, but it happens.
Right. Welcome to the Deep Dive, everyone. Today we are unpacking the surprisingly complex world of European finance. We're specifically focusing on Luxembourg private banks that serve clients who actually reside in Belgium.
Yeah, and our overarching mission today is to, really dismantle this incredibly pervasive misconception in the financial sector.
Which one?
The idea that operating across European borders is simply a matter of, expanding your sales territory. Like a bank finds success in Luxembourg, so management just decides to scale up by calling high net worth individuals in Brussels or Antwerp or Ghent.
Like they're treating it purely as a marketing expansion. Like you're just adding a new zip code to your CRM software and maybe hiring a few people who speak French and Flemish.
Exactly.
Yeah.
But the legal sources we're analyzing today paint a completely different picture. They really break down the actual regulatory framework behind these operations.
Yeah, they do. And the central thesis we're going to explore here is that a client's mere physical residence fundamentally shifts the entire legal and operational perimeter for the bank.
It changes everything.
It really does. So whether you're a financial professional, a compliance nerd, or just someone fascinated by how European rules actually work in practice, we are going to look at the hidden gears turning behind every single cross-border transaction.
And to really understand those gears, we have to start at the foundation, right? Which is the European passport.
Ah, the famous European passport.
Right, because in theory, the passport is what allows a financial institution that's authorized in one EU member state to provide services in another.
So let's ground this in a realistic scenario just to see how this passport actually functions in the real world. Let's introduce a hypothetical client.
Okay, I like hypotheticals.
We'll call him the heir to a Belgian brewery.
A brewery heir. Nice.
Right. So he lives in Brussels. He just sold a major stake in the family business, and he's looking to set up this complex investment portfolio. And he decides he wants to use a prestigious private bank in Luxembourg. So, legally speaking, how does the bank even begin to open its doors to him across that border?
Well, legally, this starts with the EU's CRD4 directive, which governs credit institutions, and the MiFID II directive.
And MiFID II governs the investment services side of things.
Exactly. And Luxembourg baked both of these directives into its own national framework. Specifically, they did this through the Law of 5 April 1993 on the financial sector and the Law of 30 May 2018 on markets and financial instruments.
Right. So those established the baseline for the freedom to provide services in another member state.
Yeah. So the Luxembourg Bank relies on those transposed laws to say, we have a European passport. We can absolutely take on this Belgian brewery heir as a client.
But based on our sources, this is where the commercial optimism kind of clashes with regulatory reality.
Very much so. The passport is so often misunderstood.
Yeah, I look at the European passport very much like a standard driver's license.
How do you mean?
Well, your Luxembourg-issued driver's license gives you the legal right to take your car out on the road and drive it across the physical border into Belgium, right? You are a legally recognized, fully licensed driver.
Right.
But having that license absolutely does not mean you can just ignore the local speed limits or parking rules or traffic laws of the country you're driving in.
That is a critical distinction. It's perfect, actually, because passporting does not override Belgian local rules.
Oh, it doesn't?
No, not at all. A bank might be fully licensed and, heavily regulated in Luxembourg. The entire banking relationship might even be managed by a team sitting at a desk in a Luxembourg office. However, the simple fact that our hypothetical brewery heir resides in Belgium completely changes the legal landscape. The bank cannot simply operate under Luxembourg law and just, call it a day.
So to navigate that dual country landscape, the sources lay out a very specific roadmap. It consists of 3 core legal perimeter checks that a bank has to perform before they even think about offering a product. Let's dig into check 1.
Let's do it.
Check 1, the authorization sandbox.
Right, so check 1 is about confirming that the specific activity you want to perform in Belgium is actually covered by your Luxembourg authorization.
Okay.
The bank has to ensure their intended services align with the CRD4 and MiFID II directives, and importantly, they have to file a formal Freedom to Provide Services notification.
Okay, wait, I want to play devil's advocate here for a second.
Go for it.
If I'm a fully licensed, heavily regulated bank in Luxembourg, I already know what I'm allowed to do?
Yeah.
Like, I passed the regulatory exams. I hold the banking license. Why is this extra notification step to the host country so critical? It honestly just sounds like redundant administrative paperwork.
I get why you'd think that. You'd think a banking license is just this blanket permission slip. But it's actually about formal intent. It's about defining the precise scope of your operations.
Oh, I see.
Yeah, you can't just silently assume your Luxembourg license covers every specific financial action you might take in a foreign market. You have to explicitly notify the regulators of exactly which services you intend to passport across the border.
So, keeping with the car analogy, you basically have to declare the exact model of car you're driving and the exact roads you plan to take before you even cross the border.
Precisely. It ensures that the specific investment products or credit services you are offering to that Belgian client perfectly match the legal permissions you've been granted back home. You are legally defining the sandbox you're going to play in.
Got it. Which brings us to check 2. And looking at the documentation, this is where the real friction happens for cross-border operations.
Oh, definitely. Check 2 is tough.
We're talking about navigating the host country's rules, known in Belgium as the Règle d'intérêt général, which translates to the rules safeguarding the general interest.
Yeah, and this is an absolute minefield for legal and compliance department.
The minefield, really?
Oh, absolutely. When a Luxembourg bank operates in Belgium under the freedom to provide services, they are legally obligated to apply these Belgian rules.
Mm-hmm.
And to help institutions navigate this, the Belgian regulators, that's the NBB and the FSMA, they publish a list of provisions that may apply to credit institutions operating within their borders.
Okay, but wait, I'm reading this, and this NBB list is explicitly labeled as non-exhaustive.
Yep, non-exhaustive.
That sounds like a complete nightmare for a compliance team. I mean, how are you supposed to prepare for an audit or build a compliance framework when the syllabus for the test is basically just, everything?
That non-exhaustive nature is exactly why cross-border banking requires such deep legal analysis. It can't just be a clever commercial strategy.
Right.
A non-exhaustive list means the burden of discovery and compliance rests entirely on the bank's shoulders. They have to actively interpret Belgian economic and financial provisions to make sure they're in line.
So let's apply this to our Belgian brewery heir. The wealth manager in Luxembourg wants to offer him, say, a structured financial product. It's completely standard, widely used, and fully compliant under Luxembourg law.
Okay. But under Check 2, the bank can't just assume that because it's legal in Luxembourg, it's ready for the Belgian market.
They can't.
No. The compliance team has to look at that specific product and ask, could this structure inadvertently violate a Belgian civil code? Or does the way we market this product run afoul of local Belgian consumer protection rules?
Wow.
Because the non-exhaustive list applies without prejudice to a whole host of other Belgian rules.
Yeah.
We're talking civil law, commercial, criminal, tax, and even privacy laws.
That completely redefines what cross-border strategy actually means. I mean, you can't just say, well, we have a Belgium desk with bankers who know the cultural nuances of Brussels.
No, not at all. That's just marketing and customer service.
Right. True operational compliance means your legal team has done a rigorous, granular analysis of how your specific Luxembourg product mechanically interacts with Belgian general interest protections.
And crucially, that analysis must be ongoing. If Belgian consumer protection laws change, the Luxembourg Bank has to adapt its cross-border offerings immediately.
So they have to constantly monitor the host country.
Exactly. The protection of the Belgian consumer is paramount in the eyes of the host regulators, regardless of where the bank is actually headquartered.
Okay, so if the Belgian regulators are breathing down your neck to ensure you follow their general interest rules, do the Luxembourg regulators just take a back seat?
Oh, definitely.
Because that leads us directly into Check 3.
Right. Check 3 is about keeping the home fires burning, essentially, maintaining the foundational home controls. The Luxembourg regulators do not look away just because you are serving a client across the border.
Okay, so what rules still apply from home?
The Luxembourg financial sector law still strictly governs the bank's internal mechanisms. Specifically, Articles 37.1, 37.2, and 37.3 remain in full force.
And those articles cover organizational requirements, conflicts of interest, and conduct of business, correct?
Yes. And alongside those, you have the Grand Ducal Regulation of 30 May 2018.
Right, the Client Protection Regulation.
Exactly. It mandates highly documented product governance from the Luxembourg side. That covers everything from how financial instruments are safeguarded to the transparent structuring of fees and commissions.
Okay, let me see if I have the mechanical tension here right. It's very much like having strict parents at home and strict teachers at school.
Oh, that's a good way to look at it.
Right. Your strict parents, the Luxembourg regulators, they dictate how you behave internally, your morals, your structure, how you organize your life. That represents your organizational requirements and your home rules.
Yeah, they set your baseline character.
But the strict teachers, the Belgian regulators, they dictate how you behave when you're in their classroom, what you're allowed to say, how you interact with others. That represents your conduct of business and your host country's general interest rules.
Right.
So as a bank, you're the student, and you have to satisfy the strict parents who raised you and the strict teachers whose classroom you're sitting in simultaneously.
That analogy captures the operational reality perfectly. This dual layer of compliance creates an incredibly robust safety net. But as you can imagine, it requires a massive amount of coordination.
I bet.
It ensures that while the client is protected by the host country's consumer rules, the structural integrity and conflict management of the institution managing their wealth remains securely anchored in the home country's laws.
So you never really escape your home regulator.
Never. You simply add the host regulator's rules on top of them.
Wow. Okay, so we've established this incredibly complex dual master regulatory environment. But abstract legal theory is one thing. How does a bank physically prove it is managing this day to day? Like if I'm a regulator walking into a Luxembourg bank, I assume proving this compliance means the bank just keeps a log of emails and transaction receipts for their Belgian clients.
You'd think a basic audit trail would suffice, right?
Yeah.
But the sources point to something much heavier and far more structured. The bank is required to establish and maintain what is called a comprehensive, documented, and defensible Belgium country file.
Defensible is a very heavy word in the legal world.
Very heavy.
It implies anticipation of a challenge. Like it means at any moment, an auditor or a regulator from either country could walk in, point to a single transaction made by our Belgian brewery Air, and say, defend why this was allowed.
Exactly. And the bank has to be able to pull out this specific file and show all their legal math.
And that math has to be incredibly granular, doesn't it?
Oh, beyond granular. The country file is not just a folder of client contracts. It has to classify multiple variables for every single interaction. And the most critical of these is classifying the exact channel of interaction.
Because how you interact with the client completely changes which rules apply.
Completely. The file must document things like, was this an unsolicited request from the Belgian client?
Okay, meaning, did the brewery Air wake up one morning, research Luxembourg banks on his own, and just call the bank completely unprompted?
Right. That's known as reverse solicitation, and it carries a very specific regulatory weight.
Versus a scenario where the bank actively targeted him.
Exactly. Was the interaction part of a targeted Belgian marketing campaign? Did a Luxembourg banker travel to Brussels to take him to lunch and pitch services?
Or did they meet at a sponsored event in Antwerp?
Right. Or did the client use a website specifically localized for Belgium? Every single one of those channels triggers different legal implications and varying levels of regulatory scrutiny from both sides of the border.
So the channel essentially defines the intent of the bank, which heavily influences whether they're actively soliciting in a foreign market or just merely responding to a client's independent desire to offshore their wealth management.
Spot on. But the country file doesn't stop at just classifying the channel of communication.
It doesn't.
No, the channel is really just the first layer. The file must also rigorously classify the service being provided, the specific financial product being sold, and crucially, it must classify the client themselves.
Okay, and this is where the sources delivered this massive, completely counterintuitive insight for me.
The client categorization.
Yeah, we're talking about private banking. We're talking about high net worth individuals, right? Our hypothetical brewery Air just sold his family business for, let's say, 50 million euros. He is incredibly wealthy by any metric.
Absolutely.
But the sources explicitly state that a wealthy client may still be classified as a retail client under the MiFID VI directive.
Yeah.
I mean, to a layperson, treating a multimillionaire like someone opening a basic checking account sounds completely contradictory.
It does sound contradictory, but it reveals a fundamental tenet of European financial regulation. In the eyes of the law, wealth does not automatically equal institutional sophistication.
That is such a fascinating distinction to make.
Think about the mechanics of wealth creation, right? Our brewery Air is an expert in brewing, supply chains, maybe hospitality.
Sure.
He built and sold a massive tangible asset. But does that operational business expertise mean he deeply understands the mechanics of complex derivative structures or leveraged buyout funds?
Or high-risk alternative investment?
Exactly.
Often the answer is absolutely not. He knows beer, not synthetic collateralized debt obligations.
Right. The law recognizes that gap in expertise. By categorizing a high net worth individual as a retail client, the bank is legally obligated to apply the absolute highest level of product governance and consumer protection available.
Which completely upends the traditional assumption that private banking is just this regulation-light, anything-goes playground for the ultra-rich. It forces the bank to prove suitability.
That's the key word, suitability. The bank has to ensure the product is genuinely suitable for his actual financial knowledge, not just his bank balance.
Right.
They have to prove that the risks were clearly explained in a way he could understand. And they must demonstrate they aren't selling an incredibly complex, opaque instrument to someone who legally requires the exact same consumer protections as an everyday retail investor.
And all of that active interpretation, that suitability testing, and that intersection of Luxembourg product rules and Belgian consumer protection rules, all of it must be meticulously documented inside that defensible Belgium country file.
That file is the physical or digital evidence that the bank isn't just looking at the Belgian resident as a lucrative pool of capital. They have to treat them as a consumer requiring rigorous protection under a dual regulatory framework.
Man, let's bring all of these moving parts together. What the source material reveals today is that operating a private bank across European borders is an incredibly intricate, highly mechanical dance.
It really is.
It begins with the European passport, the CRD and MiFID II directives. But we've learned that passport is really just the entry ticket to the arena. It absolutely does not exempt you from the rules of the game.
No, because once you have the passport, you must systematically clear those 3 legal perimeter checks.
Right.
You have to ensure your specific authorization covers the intended activity through a formal notification. You have to actively navigate the non-exhaustive, highly complex minefield of the host country's general interest rules.
The Belgian rules.
Yes. And you have to do all of this while still maintaining your foundational home country organizational and conduct controls.
You have to keep the strict parents in Luxembourg happy while obeying the strict teachers in Belgium. And the entire process has to be meticulously documented, categorized, and defended in a country file that accounts for every single variable, from how the initial handshake happened to how sophisticated the client's actual financial knowledge is.
It really highlights the sheer depth of regulatory analysis required before a single euro is ever invested. Cross-border banking is fundamentally a legal discipline, not just a sales strategy.
It certainly is. And examining the mechanics of this framework leaves me with a final thought to ponder, really looking toward the future of the industry.
What's that?
Well, everything we have unpacked today relies heavily on understanding the physical geography of the transaction, right? Where the client resides, where the banker is sitting, where the service is technically being provided.
Yeah, geography is central to all of this.
So if a single wealthy client's physical residence in a Brussels townhouse can trigger this entire cascade of dual country compliance, what happens is the nature of banking becomes entirely virtual.
Oh, that is the existential question facing cross-border regulation right now.
Right. When client interactions no longer happen at a mahogany desk or even a sponsored event, but instead happen via mobile apps, virtual reality environments, or through AI-driven chatbots.
Yeah.
When the branch is nothing more than software on a smartphone sitting in a pocket that constantly crosses borders, how will regulators and financial institutions even define where a service is actually being provided?
The definition of a border is becoming increasingly blurry, but the regulatory tension between home and host countries, that's going to remain.
When the border is entirely digital, whose rules safeguard the general interest then? It makes that incredibly complex legal wall we discussed at the beginning feel like it's rapidly being rebuilt out of code rather than concrete.
It really does.
It's definitely something to keep in mind as the financial landscape continues to evolve. Thank you for joining us for this deep dive. We hope it gave you a new appreciation for the hidden gears turning behind the scenes of European finance. Until next time, keep looking past the surface.